The matter of my daughter's father needs to be put to end. It's been 6 years. I've become a victim of this matter for very, very many years, and I'm tired. I'm going to speak. I am no longer afraid of speaking.
Oh, wrong video. I'm so sorry. This is the video I meant for you to listen to.
Although the first applicant says that his incarceration amounts to torture in terms of Rule 43 of the United Nations Standard Minimum Rules for the Treatment of Prisoners, the so-called Nelson Mandela Rules, his case really hinges on the allegation that his further incarceration at CMAX is in conflict with the respondent's own standard operating procedures that only allow for the incarceration of a prisoner in CMAX for 18 months, save in certain exceptional circumstances. The first applicant has been years. In my view, if a prisoner is incarcerated unlawfully, an application to rectify the position is inherently urgent. I will deal hereunder with the averment that the first applicant is unlawfully incarcerated. The first applicant has also alleged that the conditions under which he is incarcerated have caused him to suffer a mental breakdown. The allegation is denied by the respondents in a perfunctory manner, but they have made no effort to investigate the first applicant's complaints. They do not believe that the first applicant's averment should be rejected out of hand. I find that, as far as the first applicant is concerned, the matter is urgent. The same cannot be said for the second applicant. Although he says that he is also the victim of the same allegedly inhumane circumstances in CMAX, his continued incarceration falls within the four walls of the Correctional Services Act.
Hello, honorable members of the clan. So let's go to the Gauteng High Court, that is the Pretoria High Court, where accused number 3 and 5's application, urgent application, was heard this morning. And well, the results were that Mr. Ncube is to be released immediately out of the solitary confinement. However, for accused number 5, there was not sufficient evidence or sufficient facts that would make his application urgent, even though it's got some urgency. I was like, okay, I'm a little bit confused. What are you saying here, Mr. Judge? I forgot his name, actually. And so, unfortunately, for accused number 5, he will remain the way he is. The status quo will remain. However, Mr. Ncube, that is accused number 3, he is going to be removed from solitary confinement because his incarceration there, it is unconstitutional. Which kind of like brings me back to what I had said in my video some time ago, where I said public servants, or if anybody wants to be a public servant, they must at least have this one prerequisite, or amongst the prerequisites that are required for you to get the job, to have sat in a constitutional law class for a year. Everybody. Whether you are going to do that on your own accord, or you are going to take courses that are going to include constitutional law. But the look of things, it looks like even LLB itself, or not like the entire LLB or the hardcore law, maybe some few little LLB courses must be added on. But most importantly, the Constitution, because I cannot understand how the management of an entire CMAX would not know that putting somebody in solitary confinement, what am I saying? Putting a person in solitary confinement for so many years, when the legal, I think the legal limit is 90 days, but as well on certain circumstances, according to what I heard the court say, it is unconstitutional beyond that. And you're telling me these people did not know that this is unconstitutional, what we are doing to this man who's been in solitary confinement for the past 4 years? No. Somebody needs to be held criminally liable for this. It cannot just slide like that. It cannot slide like that. The Minister of Correctional Services needs to hold whoever, the warden of Kgosi Mampuru prison, accountable. And I'm talking criminally accountable, because 4 years having a person in solitary confinement, I was even shocked that he even had a mental breakdown. I mean, I'm thinking, yeah, we are social beings as human beings. There is no way, well, except for some of us who can actually live without people for a very long time and will still be fine at the end of the day. And so human beings are social beings, and to think that his day, he only has an hour of just not even seeing the sun, the rays of the sun hitting his face just for an hour. 30 minutes phone call a month, 10 minutes phone call a month, and 30 minutes visitation a month, and an hour consultation with his legal team. That is unconstitutional. How are they supposed to have a fair trial if the legal lawyers or the legal team has to come there and literally speak like, you understand? Okay, and then some things will have to wait until another opportunity is given. This is wrong in South Africa. This cannot be South Africa. This is a dictatorship. Whoever is the management of Kgosi Mampuru, I am so sorry, sir or ma'am. You are not right for this job. Absolutely not right for this job. Because you know Section 35 of the Constitution, it is very strong in the rights of incarcerated people, detained people, people that are accused. Remember, they are still innocent until proven guilty. And then the part that also gets me, it's not like the investigating officer did not know about this situation. And you have to ask yourself a question, why must he be in solitary confinement? Is that not another form of torture? Which now takes you back to the confessions. It takes you back to the confession because solitary confinement, according to this judgment, is tantamount to torture. So now let's go to accused number 1 and accused number 2's confessions. Is that not torture that they say they experience in the hands of Gininda and his people? So now I think that accusation is solid for me, that it is reality. It is because now they were using the law to torture accused number 3 for 4 years because he would not accept to confess so that this matter is put to rest. And another thing, I think the reason why they were separating accused number 3 and 5 so that they don't meet and then they speak the same language on the stand. They speak the same language on the stand. But anyways, why would they meet and speak the same thing on the stand when they know very well where were they on the 26th of October 2014? Why should they even have any conspiracy to create a narrative that is going to suit their defense? So this is not good for. It's not good for the state. This judgment, because Baloyi knew about this, Gininda knew about this, the state knew, NPA knew, and they did nothing. And travesty of justice was being executed right at their watch. I mean, we have Mr. Tefu, who is in prison without a trial in South Africa. In South Africa. How are we supposed to now, as ordinary people, think that if we go to the criminal justice system, justice is actually going to be served for us? How do we know that? And I'm telling you, the faith in the criminal justice system is almost non-existent in many people, myself included. And the judiciary is also skating on thin ice because of what we are witnessing in the North Gauteng High Court in Judge Ratta's courtroom. And all of that is diminishing right before our eyes. This is not right. And I say it again, there's got to be, if you're a lawmaker and you listen to my channel, either you do this as, propose this bill. All public servants must have a constitutional law, knowledge, meaning they have sat in a constitutional law class or course for 12 months. And they've passed this course and then give an aggregate on how you are going to be accepted into this job. Because clearly there are a lot of other unconstitutional practices out there that are happening to the people of South Africa. Home Affairs, but Home Affairs is beginning to rectify itself which I am very happy about. But the police, let's talk about the police. Let's talk about what do you call this, small business development, not. There are a lot of unconstitutionalities that are happening on the people of South Africa. The age thing, that this program is only for 18 to 35 years old. Everyone else is incapable. The largest constituency that goes out and vote, they don't sit at home and go to taverns. They actually go stand in a queue and vote, and those are the people that you are alienating. That is unconstitutional. That is unfair discrimination. It's not equal. So those are the things that I'm trying to say, that I think in order to be able to fix some few things, let's get the constitutional causes also added on the prerequisites to get employment in South Africa for public servants. I don't know. That's just, or public administration. Is it public administration? Yeah, I think it's public administration. Other than that, guys, that is what I just wanted to update you about. Mr. Mncube, accused number 3, is now out of solitary confinement. I'm not sure if he's already out, because it was an urgent application which was successful. Unfortunately for accused number 5, Mr. Ntuli, his status quo remains. And I'd like to check a little bit deeper why, because of course the sources that we got this from, they also did not go in depth. We didn't hear the entire judgment, but I'm sure I'm going to get hold of it, and I'll come back to you and let you know why Ntuli was not, his application was deemed not urgent. However, Mr. Mncube was. And then we'll talk again. We'll talk again most definitely. And I will see you guys a little bit later. Goodbye.